And Mr. Milligan, Mr. Florio, you both are free to cut your camera if you want until your case is called. And Mr. Milligan, Mr. Florio, you both. Okay, before I get started, there was a problem with the computer system this morning, and we were not able to get the paperwork that I needed from magistrate court to move your cases until 1 o'clock. And then that takes a little bit of time to get those forms and things that you all filled out and bond orders that I filled out. Probably 95% of you, maybe close to 97, 98, you're going to get bonds. And just so that you understand the way that things work, I have to complete the paperwork after this hearing. And I'm going to try to move as quickly as I can, but it's my duty to answer any questions that you may have. So you can ask whatever question that you want to have, but just understand that just prolongs the proceedings, and that prolongs the time until you can get out of jail, because it's going to take me probably at least an hour after the hearing is over to process all of the paperwork and send it back to the sheriff's department so that they can input the information as it relates to your cases and get you to the point where you can bond yourself out. So with that being said, this is your first appearance hearing before the Magistrate Court of Clayton County. My name is Brad Gardner, and I'm a judge in this court. I'm not here to conduct a trial of your case or to take a plea in your case. I am here to inform you of the charges that have been filed against you, to advise you of certain rights, to set bail on those offenses that I'm authorized to set bail, to schedule a preliminary hearing, and to determine whether you require the assistance of an attorney. You have the right to remain silent and say nothing, but should you give up this right, anything you say during this proceeding may be used against you if your case goes to trial. So please don't discuss the facts of your case. During this and all other proceedings, you have the following rights: the right to the presumption of innocence, the right to indictment by a grand jury for most felonies or by accusation for misdemeanors, the right to a speedy and public trial by jury, the right to see, hear, and question witnesses who are called to testify against you, the right to compel the attendance of witnesses to testify on your behalf. Uh-oh. Okay. Let's see. All right, we're back. Okay, you have the right to see, hear, and question witnesses who are called to testify against you, the right to compel the attendance of witnesses to testify on your behalf. Are we back? It looks like it cut out and then froze. Okay, all right. The right to compel the attendance of witnesses to testify on your behalf, the right to testify on your own behalf or offer evidence in your own defense, the right to have an attorney represent you. If you cannot afford an attorney, one can be appointed to represent you if you qualify. Some of you will be allowed to post unrestricted bonds for your release from jail. These bonds may be posted by cash, commercial, or property. If you post a cash bond, someone will deliver the full amount of the bond and fees in cash to the sheriff's office. The sheriff's office will hold the cash and return it at the end of the case. If you use a commercial bonding company, someone will have to pay a fee to the company for their service. The fee will not be returned. I don't know what fee will be charged, but it is usually based upon a percentage of the bond. Finally, if you use property to post a bond, the property would need to have a net equity at least 3 times the total amount of the bond. Some of you will have special conditions on your bond that prohibit you from contacting certain people or going to certain places. This special condition will be provided to you on a separate form. You will also be prohibited from contacting the victim while you're in jail. If you violate the court's order, your bond will be revoked and you could remain in jail until your trial. You could also receive additional felony charges. It is important to note that if someone is listed as a victim in your case, that person will not be allowed to post your bond. Some of you are charged with offenses for which this court is not authorized by law to set bail. In this event, a bond hearing will be scheduled before a judge of the Superior Court of Clayton County, and you will be informed of that date. If you are currently on active probation, this court is not authorized to set bond at this time. Where the bond is appropriate in your case will be reconsidered after your probation officer has had an opportunity to consider this new arrest. The purpose of a preliminary hearing is to determine whether there is sufficient evidence to support the allegations against you. The standard at this stage is very low. A judge determining whether a charge goes forward at this stage only has to determine that it is possible that the crime occurred. Everyone has the ability to waive their right to a preliminary hearing. However, you should speak to a lawyer first if you are unsure about whether it is appropriate to waive your preliminary hearing. If you post bond, your preliminary hearing is automatically waived. You will receive notice at the address you give of your next court date. Finally, I need everyone to raise their right hand.
You're frozen again.
Okay. Do you need me to go back and repeat anything that I said? I did not understand that.
So we can still hear you. Your picture froze. That was it.
Okay. Do you swear or affirm that any statements you make during this proceeding will be the truth, the whole truth, so help you God?
I swear.
Okay. So let's start on the male side with Mr. Zayas and Mr. Couture. And we'll start with Mr. Zayas.
They're going Mrs. Zayas, Your Honor.
Okay. And Mr. Florio, I'm not seeing a Mr. Couture.
Judge, it's Cuttray.
Oh, I see it. Sorry.
Yes, sir.
I see it on the paperwork. I didn't see it on the CAA form. So I do have him. Because of everything that went on this morning, I didn't get a normal like call sheet, basically is what I call it, to see that everybody who is on. So we'll go back to Mr. Zayas. So, Mr. Zayas, I would normally speak to you directly, but you have taken advantage of the opportunity to hire a lawyer, Mr. Milligan. And Mr. Milligan and I have had some conversation today as it relates to my keeping him informed of what was going on as it relates to the computer outage. You need to understand, Mr. Zayas, that anything you say here is not private. So don't say anything you don't want the whole world to know. Do you understand that?
Yes.
Okay, so Mr. Milligan, you and I had a brief conversation, and I told you that as I go through this paperwork, I make initial determinations as it relates to bond, and I made an initial determination to deny bond to your client, but I will hear from you as it relates to anything you want to tell me about either this case or your client.
Thank you, Your Honor. As the court's aware, the purpose of a pretrial bond is to prevent punishment before a conviction and to secure the appearance of the person in court for trial. Mr. Zayas has significant ties to the community and poses no risk of flight and no risk of failing to appear in court as required. He is 50 years of age. He's got a number of grown children and some minor children who depend on him for support. He has lived in Clayton County for more than 20 years. In addition to his children here, he has a wife and numerous aunts, uncles, cousins, and other relatives in Georgia. So he has significant ties here in Georgia. His employment status and history and his financial condition are also considerations for the court. He is employed as an installer for ADT. He has been employed as an installer for ADT and is still gainfully employed since approximately 2005. He has a stable job. His job is being held for him pending his release on bail. With respect to his reputation, character, and mental condition, his reputation is that of an honest, decent person of high moral character. He keeps his promises and he meets his official obligations. With respect to his past history of response to legal process, he has always responded to legal process in a timely manner. And as far as I know, has never been accused of obstruction, giving a false name, escape, or any sort of failure to appear. In fact, in this case, Your Honor, when we found out about this warrant, Mr. Zayas contacted me and we voluntarily turned him into the jail yesterday, meaning he wasn't sought by the police. We turned him in yesterday afternoon for him to be booked into the jail. He wasn't seeking to avoid prosecution or run or stay out any longer than need be. I think the warrants were issued a couple days ago, so I think it was basically a day or two between the issuance of the warrants and when he turned himself in. We don't have access to his prior criminal history, which I believe the court has, but I think there hasn't been anything for more than 10 years. And on my understanding, I don't think he's got felony convictions, but I'm not positive about that. If he does, I think they're more than 10 years old. Granted, the nature of the current charge, another factor obviously is the nature of the current charge, the apparent probability of conviction, and the likely sentence, insofar as they are factors relevant to the risk of non-appearance. Although he faces serious charges, these are charges that Your Honor is allowed to set bond on. They're not Superior Court bond only. They're not 7 deadlies. There is no mandatory minimum. And although the allegations are what they are, and I'll get into the facts very briefly because I don't think the facts are that important for purposes of bond, I don't think that the potential sentence, if convicted, is such that would suggest any sort of likelihood that Mr. Zayas would flee. Mr. Zayas poses no significant threat or danger to any person, to the community, or to any property in the community. Mr. Zayas poses no significant risk of committing any felony pending trial. Mr. Zayas poses no significant risk of intimidating witnesses or otherwise obstructing the administration of justice. Obviously, there's no prosecutor here, but I don't think that if there was, that the state would be able to prove that preventive detention is necessary, and that burden, of course, would be on the state. Your Honor, there's no reason to think or suggest that additional bail or no bail would be necessary to assure the safety of the public or any of the alleged victims, and I'll get into that in a little bit more in a minute. As far as I know, Mr. Zayas has never committed a crime while out on bond, has never threatened a witness, and in the absence of such evidence, it would be improper for the court to assume that there's a substantial likelihood that he might do that when released. Now, while I normally would argue that the facts of the arrest are irrelevant, because the only issues typically to be decided on bond is whether a bond is necessary to assure his presence, and whether further restraints on his liberty are needed to protect the public and potential witnesses. Here, Your Honor, Mr. Zayas is presumed innocent of the current charges. I was given a copy of the warrant application that details, there's details in there, which I'm sure the court has seen. As the court can see, the allegations for the first set of charges, or for the first count, would be from approximately 16 or 18 years ago. This is not something that occurred recently. The allegations for the second set is from approximately 10 years ago, and the allegations from the third set is from approximately 4 years ago. And I point that out to suggest that he is no immediate risk to anybody, whether it be the alleged victims or the public as a whole. We're asking Because there are no facts which support a finding that Mr. Zayas will fail to appear, because there's not any clear, convincing evidence that Mr. Zayas presents an identified and articulable threat to any individual in the community at this time, we would suggest that the court should grant a bond. And, I was going to ask for a lower bond, but it should be enough to emphasize the importance of Mr. Zayas to appear at trial, and something that's commensurate with his financial conditions. And finally, Your Honor, to the extent the court is concerned about any sort of contact with the alleged victims, the court can use special conditions, and I would encourage the court to think about using special conditions here. Although he's charged with what he's charged with, and I'm not going to say it because I guess we're public here.
Right.
Mr. Zayas does not pose a risk to any other persons. And a special condition prohibiting contact with the alleged victims, we think, would be sufficient and adequate to protect the community as a whole. Given all of those factors, we're asking the court to set a bond somewhere in the neighborhood of $25,000 or $30,000, which we think would be high enough to ensure his appearance, yet not too high to prohibit him from getting out of jail.
I mean, you have made a compelling argument. I'm willing to post a bond. One question that I have is, it appears from the CJA form and from the warrants that the alleged incident location is where Mr. Zayas lives. Do you have any information about that?
Yes, Your Honor, that is where he lived. He has not been in that residence for about 8 months.
Okay, so if I place stay away provisions on the bond to stay away from the alleged victims, there wouldn't be an issue as it relates to him interacting with them.
That's correct, Your Honor. He does not live there with them. That's correct.
Okay, so I'm willing to set a bond at $15,000 for each. Although it says 3 counts as it's written on the warrant, I only have one count for each alleged offense. So I'm just going to set 15 for each. So that'll be a $30,000 total bond. I'm going to also place a stay away provision on the bond for Mr. Zayas to stay away from. I have to name the alleged victims. Mr. Zayas, I'm placing a condition on your bond for you to stay away from a Tania Zavala, Kiana Ortega, and Adeline Brito. Do you understand that, sir?
Yes.
Okay. Normally, if we were in court, he would be signing off on a stay away provision, but I direct that attention to them and get a response. So at least I have a positive response that I've gave them the condition and they've indicated that they understand. There's going to be a preliminary hearing that's going to be set for June 30th at 8:30 in the morning. But that date will get waived upon your bonding out and you'll get a new court date in the mail. I do take it, just so you know, I do take it as a positive sign when people take the expense of hiring an attorney to represent them as it relates to the charges. It at least gives me an understanding that they are taking this seriously and that this isn't a situation where they may resort to self-help, as it may be called. Mr. Milligan, is there anything else that you want to address with me, sir?
No, Your Honor. Just I want to thank you for keeping me informed today about that. Is there a way that I can get a copy of the bond order once it's completed?
Yes, so I have, and that's one of the things that we were locked to. I have the bond order now printed out. So that's the information I'm filling in. And the bond order will get sent back to the sheriff's department today. Because you and I have communicated today, I would be willing to send you a separate copy so that you have it. But it's not going to be official until it's entered into the system with the Sheriff's Department.
Yes, sir. I appreciate that. Thank you, Your Honor. That concludes my business. May I be excused?
Yes, sir. Have a good day.
Thank you. You too.
Mr. Zayas can be sent back.
Okay, Your Honor, I have Mr. Cutray.
Okay. So, Mr. Florio, I preliminarily set a bond for your client at $5,000 with a stay away provision to stay away from a mini Jackson. But I will hear from you, sir. Is there anything that you want to tell me about your client?
Yes, sir, Judge. Mr. Cutray is 18 years old. This is his first and only arrest in life. He has no other criminal history. He lives here in Jonesboro with his mother and his 3 sisters, and formerly worked at the Arby's right down the street from the courthouse over on Terra Boulevard, and is no longer employed because he left that job to help with his disabled sister. He has a 5-year-old sister at home who suffers from cerebral palsy. I spoke with his mother this morning. His mother immediately retained me upon him being arrested yesterday. And her, candidly, Judge, her financial resources are very limited because she is a single mother with 4 children, all who live in the home, and a special needs child. And so she's self-employed and kind of finds herself in a position of having to take care of everyone. I would ask that the court take that into consideration in the bond amount for Mr. Cutray, especially in light of his lack of criminal history and his age. I think what this case is going to wind up being, Your Honor, is going to be kind of a disagreement between a bunch of teenagers and friends of the family and folks that have known each other for years, and obviously an allegation that there was some property damaged as a result of some disagreements. And so I appreciate the court setting bond, but we would ask that the court take Mr. Cutray and his family's financial position into consideration in setting bond for him this afternoon.
Okay, give me a second. Let me look to see if there's anything in his criminal history. I'll tell you, I was a little bit concerned about the allegation. When I'm setting bond, I think about everyone is here presumed to be innocent. So setting bond is not about whether it's to punish them or not, but it's to consider the allegations.
Yes, sir.
He does not have a criminal history. So I will reduce the bond amount to $2,000.
Thank you very much for that consideration, Your Honor.
Okay, he's going to have a preliminary hearing date set for June 29th at June 30th at 8:30 in the morning. This is being written up as a felony. And that date will get waived upon his bonding out, and he'll get a new court date in the mail. Is there anything else, Mr. Florio?
No, sir, Your Honor. Thank you very much for that.
Okay, sir, you're free to go, Mr. Florio, and Mr. Cutray, you're free to go back, sir.
Thank you, Your Honor. Have a good weekend, Judge.
You too.
Thank you, sir.
All right, let's start on the ladies' side.
Sophia Barnes.
Okay, Ms. Barnes, ma'am, you've been charged with 1 count of driving a vehicle with an expired tag, 1 count of driving a vehicle with a suspended license, and 1 count of concealing the identification of a motor vehicle. These charges are all set by schedule, which means they're automatically set. So you're gonna have a total bond of $2,500. Do you believe you can post that bond, ma'am?
Yes.
There's gonna be a preliminary hearing date set for June 29th at 8:30 in the morning. That date will get waived upon your bonding out, and you'll get a new court date in the mail. Do you want me to see if you qualify for the appointment of a lawyer?
Yes.
Okay, you do qualify, ma'am. I'm going to appoint a lawyer to represent you. Do you have any questions for me?
No.
Okay, ma'am, you're free to go back.
Thank you.
Is it Miss Barea?
Desiree Barrera.
Okay, ma'am, you've been charged with 1 count of battery. Bond is going to be set at $5,000. Do you believe you can post that bond?
Excuse me, Honor, could you repeat that?
I'm sorry. Do you need an interpreter, ma'am?
Yes.
Okay. All right. Let me try to get someone. Put her back, and I'll try to get someone.
Thank you.
Christina Colbert?
Okay, give me 1 second. I'm trying to communicate with the office so that we can get. All right, give me 1 second. I'm gonna have to call the office. Okay, so we had an interpreter hanging on, and when I was told we didn't need an interpreter, I released her. So I called the office, and they're trying to get her back on so that she can be ready. So we'll just hold Miss Barrera until we get the interpreter back. Are you Miss Colbert?
Yes, Your Honor.
Ma'am, you've been charged with 1 count of criminal trespass. I've set the bond at $3,000. Do you believe you can post that bond?
I believe so.
I'm going to set a preliminary hearing date for June 29th at 8:30 in the morning. That date will get waived upon your bonding out, and you'll get a new court date in the mail. Would you like for me to see if you qualify for the appointment of a lawyer?
Yes, Your Honor.
Okay. Ma'am, you do qualify. I'm going to appoint a lawyer to represent you. Do you have any questions of me?
No, Your Honor.
Okay, ma'am, you're free to go back. Tell me your name, ma'am.
Brianna Tyler.
I'm sorry, say that again.
Brianna Tyler.
Okay. Miss Tyler, ma'am, you've been charged with 1 count of disorderly conduct and 1 count of family violence battery and 1 count of criminal trespass. You're going to have a total bond set at $3,000. Do you believe you can post that bond, ma'am?
Yes, sir.
You're going to have a preliminary hearing date that's going to be set for June 29th at 8:30 in the morning. That date will get waived upon your bonding out, and you'll get a new court date in the mail. Would you like for me to see if you qualify for the appointment of a lawyer?
Yes, sir.
Okay, ma'am. You're on the edge, but I'm going to find that you qualify. I'm going to appoint a lawyer to represent you. Do you have any questions of me?
Yes, with other charges between me and the victim, will I be able to drop them?
Oh, Jesus. You know what? I'm sorry, Miss Tyler. I was writing on the wrong document. You're talking about Mr. Rogers?
Yes.
give me 1 second. I have to communicate with my office. I'm sorry, ma'am. Okay, ma'am. I'm sorry. Let me see. Okay, so both you and Mr. Rogers were arrested.
Yes.
And I placed stay away provisions on his bond to stay away from you, and I'm placing stay away provisions on your bond to stay away from him. Now, we don't know what happened. The stay away provisions, they can be removed. You would have to let the Solicitor General's office know that you're not afraid of him to have his bond conditions changed. He has false imprisonment charge. That's a felony. So your cases are going to be prosecuted in 2 separate courts. His is going to be in Superior Court. Yours is going to be in State Court. So he would have to, you would have to contact the District Attorney's office to let them know that you are not afraid of him. And we placed these stay away provisions on because whatever led to the 2 of you being brought before me today, we don't want that to resurface or reignite later on tonight, because you're both are going to get bonds and you're both going to be able to bond out.
Yeah, it's just, we have a 2-year-old son, so we're gonna be around. I was just trying to figure it out.
It's, I mean, and that's, you know, that complicates things. It really does. And that's something that I can't deal with today. I can't solve that today. I will say this, and I'll say this to Mr. Rogers also. I'm coming up on 20 years of being married, and my wife and I have had arguments. Police have never been called. I don't know what's going on with this generation now, honestly, because half of my calendar is battery, criminal trespass, people breaking people's phones, people breaking doors, people. I don't know. I don't know why that's happening, but you and Mr. Rogers need to understand that your energy should be placed into that 2-year-old. And so you're never before a judge asking what's going to happen to my child, because the mother and father can't get along, or the mother and father did something. And I'm sorry that, I have to be the person to be that preachy person or whatever, but that's just a reality. So I don't know what's going to happen to your child. I hope that someone was called that was a relative, grandparent, or someone.
You know his grandmother.
Okay, good. Because you don't want your child to be in a foster home. You don't want your child to be in defects custody. So moving forward, I trust that both you and Mr. Rogers will, when you get mad at each other, you'll move on to something else. Okay? I did appoint a lawyer to represent you. Do you have any other questions, ma'am?
No, sir.
Okay, you're free to go back.
Thank you.
You're welcome. We have, she went away. Oh, Miss Bermudez, how are you? So, Miss, is it Barrea?
Barrera.
Okay, ma'am, can you see and understand the interpreter?
Señora, ¿puede usted ver y entender a la intérprete?
Sí.
Yes.
So, this is your first appearance hearing before the Magistrate Court of Clayton County.
Esta es su comparecencia inicial ante el Tribunal de Primera Instancia del Condado de Clayton.
And I'm going to try to condense what I normally say to just give you the high points.
Y yo voy a tratar de resumir lo que normalmente yo digo y solamente darle la información que es más interesante para usted.
You're being charged with battery and your bond amount is $5,000.
A usted se le acusa de agresión corporal y su fianza es de $5,000.
Do you believe you can post that bond?
¿Cree usted que va a poder pagar su fianza?
Sí, esa fianza, tengo una pregunta.
Yes.
Esa fianza, ¿tengo que pagarla de una vez o cómo es? Porque es primera vez que estoy en un proceso como este.
I have a question. The bond, do I have to pay right away or how does that work? Because this is the first time that I'm being in a process like this.
That's a fair question.
Es una pregunta que es justa.
You're going to have 3 ways that you can post this bond.
Hay 3 formas en las que usted va a poder pagar esta fianza.
The first way will be to pay the entire bond amount and fees to the sheriff's department.
La primera forma es que usted podría pagar la cantidad total a la comisaría de este condado más las tarifas adicionales.
The sheriff's department will hold that money and then return it to you when your case is over.
La comisaría se quedaría con este dinero y se lo reembolsaría tan pronto el caso termine.
The second way is through a bonding company.
La segunda forma sería usando una compañía fiancista.
You will have to pay a fee to that company that will not be returned to you.
Y usted le tendría que pagar una tarifa a esta compañía, pero esa tarifa no le sería reembolsada.
I don't know the exact amount, but it's generally 10 to 12% of the bond amount.
Yo no sé cuál sería la cantidad total, pero generalmente ellos cobran entre el 10 y el 12% de la cantidad total de su fianza.
You will pay that amount to the bonding company and then they will act as the surety, meaning they will guarantee to the court that you will show back up for your court case.
Usted le pagaría esa cantidad a la compañía de fianza y ellos le servirían como una especie de seguro. O sea, ellos le asegurarían al tribunal de que usted va a regresar a la corte.
The last way is that if you have property in this county, you can use the property to post your bond.
Y la tercera forma es que si usted tiene propiedad en este condado, usted podría usar esa propiedad para asegurar su fianza.
The property will need to have a net equity at least 3 times the bond amount.
Y la propiedad tendría que tener un capital neto que sea por lo menos 3 veces la cantidad total de su fianza.
The sheriff's department will place a lien on the property, and when your case is over, they'll take the lien off.
Y lo que ocurriría es que la comisaría le pondría un embargo a esta propiedad y cuando su caso termine, entonces ellos se lo quitan.
Do you
Okay.
understand? Do you understand now?
¿Entiende usted ahora?
Sí, antes de continuar, quiero aportar algo.
Before we continue, I would like to say something.
Ok, ayer durante el arresto, el policía me dijo que de los $5,000 que yo tendría que pagar solamente el 10%.
Yesterday, during my arrest, the police officer told me that out of the $5,000, I will only have to pay 10%.
So there are, I think, maybe 5 bonding companies that are allowed to write bonds here in Clayton County.
Acá en el condado de Clayton, yo creo que hay unas 5 compañías de fianza, las cuales se le permiten ejecutar una fianza por usted.
The sheriff's department has that list and they will give it to you so you can contact those companies.
La comisaría tiene esa lista y ellos se la darían a usted para que usted se pueda poner en contacto con ellos.
But no one except that company can guarantee you what fee they will charge.
Pero no hay nadie excepto la compañía que le pueda garantizar cuál sería la tarifa que ellos le van a cobrar.
What the officer was probably doing was giving you his best guess.
Probablemente lo que el oficial estaba haciendo era dándole su mejor estimado.
You should contact the bonding companies directly and call all of them because you may get a better result.
Usted puede ponerse en contacto con las compañías de fianza directamente y debería de llamarlos a todas, porque así quizás puede conseguir un mejor resultado.
There's going to be a stay away provision on your bond to stay away from an Isaac Zapata. Do you understand that?
Y va a haber una condición especial en su fianza. Que dice que usted tiene que mantenerse totalmente alejada de Isaac Zapata. ¿Entiende
No,
usted?
sí, entiendo. Bueno, yo soy mamá soltera, ¿ok? Yo soy cabeza de familia.
I do understand, but I'm a single mother. I'm the head of a household.
Y residimos todos en un mismo lugar.
And we all live in the same place.
You will not be allowed to be at that residence as long as Mr. Zapata is there.
A usted no se le va a permitir estar en esa residencia siempre y cuando el señor Zapata esté ahí.
Okay.
Mr. Zapata can contact the Solicitor General's office and let him know that he's not afraid of you.
Pero el señor Zapata se puede poner en contacto con la fiscalía y dejarle saber a ellos que él no le tiene miedo.
El señor Zapata es mi hijo, es menor de edad.
Mr. Zapata is my son, and he's a minor.
So the problem that this caused, ma'am,
El problema que esto causa, señora,
is that based upon whatever the police officers saw when they arrived, they decided to arrest you.
es que basado en lo que la agente policial vio cuando ellos llegaron, él decidió arrestarla.
I have no understanding as to the state of that crime scene or that scene or your house.
Yo no tengo una idea de cómo se veía el lugar de los hechos o el lugar donde el delito fue cometido o de cómo se veía su casa.
All I know is that Mr. Zapata is alleged to be the victim and you're the alleged accused.
Todo lo que yo sé es que el señor Zapata es la presunta víctima y usted la presunta acusada.
And the allegation is that you threw a metal cup that hit him in the head and cut his forehead.
Y las alegaciones es que usted le tiró un vaso de metal que le pegó en la frente y lo cortó.
My presumption is someone called the police.
Lo que yo asumo es que alguien llamó a la policía.
The police arrived.
La policía llegó.
And they determined that you should go to jail.
Y ellos determinaron que usted debía de ir a la cárcel.
Would you like for me to determine whether you can get an appointed lawyer?
Yes, sir.
Okay. You do qualify, ma'am. I'm going to appoint a lawyer to represent you.
Señora, usted califica y yo le voy a nombrar un abogado para que la represente.
You need to speak to the lawyer about the facts of your case.
Usted tiene que hablar con su abogado de cómo ocurrieron los hechos.
And allow that lawyer to represent you to the best of his or her capabilities.
Y permitirle a ese abogado o abogada que la represente usando su mejor capacidad.
Do you have any other questions, ma'am?
Yes, last one.
Okay.
Ahora, finalmente concluyendo, la fianza entonces es $5,000, ¿correcto?
So finally the bond is $5,000, correct?
Yes.
Sí.
Thank you.
You're welcome, ma'am. You're free to go back.
Gracias, señora. Puede retirarse.
Okay, so I'm gonna, before I allow Ms. Bermudez to leave, I'm gonna ask again, do we need her services for anyone else on the male or female side?
No, Your Honor.
Okay,
Not on the female side.
okay, do we need Ms. Bermudez on the male side?
No, sir. No, Your Honor. On the male side.
Okay, so Ms. Bermudez, thank you for being available today. And thank you for your patience, and you have a good weekend.
You are welcome, Judge. You have a good weekend as well.
Okay.
Bye-bye.
All right. Are you Miss Salter?
Yes, that's correct.
Okay, ma'am, you've been charged with 1 count of criminal trespass. The bond is going to be set at $3,000. Do you believe you can post that bond?
Of course.
There's going to be a stay away provision on the bond to stay away from a Tamisha Salter. Do you understand that?
100%.
Do you want me to see if you qualify for the appointment of a lawyer?
Of course.
Okay. I'm going to find that you do qualify, ma'am, even though you're kind of on the edge, the higher end, but I'm going to appoint a lawyer to represent you. There's going to be a preliminary hearing date that's going to be set for June 29th, but that date will get waived upon your bonding out, and you'll get a new court date in the mail. Do you have any questions of me, ma'am?
No, sir.
Okay, ma'am, you're free to go back.
All right, I think you said 29. 20.
So I have a question. There is a Melanie Hughes that I had placed. I continued her case to today, and I saw on the forum that it was saying that she was being combative again.
Yes, Your Honor.
So I had already set a bond for her yesterday, and I had to look into this and do a little research for someone else who was in her position. If the person is going to have conditions placed on their bond, they need to come before a judge. I had placed a stay away provision on this bond to stay away from a Rodney Peterson, but she's been given the opportunity to appear 2 days in a row, and that she's not taking that advantage of that. And all the statute requires is that the person be given the opportunity to come before a judge. So what I'm going to do is I'm going to remove the stay away provision on Ms. Peterson, and that will remove the need for her to have to appear before me. So she has a bond that's set, and that's going to go back with the paperwork today. So she has been offered the opportunity to have go before a judge, and she has chosen not to take advantage of that.
Yes, Your Honor.
So we're just going to keep it moving.
Okay.
All right, so that's it for the lady side, correct?
Correct. Yes, Your Honor.
Okay, thank you for your patience and your assistance.
Thank you.
And you have a good day.
You too. Thank you.
Okay. All right, let's switch over to the male side.
We're ready, Your Honor.
All right, I have a Mr. Is it Audi?
Audi.
Okay. Mr. Audi, sir, you're charged with 1 count of terroristic threats or acts. It's set as a felony, but I've set the bond at $3,000. Do you believe you can post that bond, sir?
I believe so.
Okay. You're going to have a preliminary hearing date that's going to be set for June 30th at 8:30 in the morning. That date will get waived upon your bonding out, and you'll get a new court date in the mail. Would you like for me to see if you qualify for the appointment of a lawyer? Okay. I'm going to find that you do qualify, sir. I'm going to appoint a lawyer to represent you. Do you have any questions for me?
No, sir.
All right. You're free to go back, sir.
Your Honor, Mr. Bakshi I never got his fugitive paperwork. I thought he was my last, but I never got his fugitive paperwork.
I did not see it either. I saw the paperwork for Mr. Klein. I was going to save Mr. Bakshi and Mr. Klein for the end, and we'll see. I'll go through the whole discussion with both of them, and if he wants to waive, then we'll need to get that done. If he doesn't, of course, he has the right to have the hearing. So if he wants to have the hearing, the waiver paperwork doesn't become an issue.
Yes, sir.
So we have Mr. Boyd next.
Yes, sir.
Mr. Boyd, you've also been charged with terroristic threats and acts, and I've also set the bond at $3,000. Do you believe you can post that bond, sir? I'm sorry. You're on mute.
I'm trying ready, I'm trying to figure out, you said I'll say it again, Brian?
Okay, thank you, Miss Bernie. Miss Bernie she's calling over to fugitive to check on Mr. Bakshi's waiver form. Mr. Boyd, sir, you've been charged with 1 count of terroristic threats or acts. I've also set your bond at $3,000. Do you believe you can post that bond?
I had to pay the full 3,000 or I have to pay the 3,000?
So you have 3 options. You can pay the entire amount to the sheriff's department. They hold it. They give you the whole amount back. You can go through a bonding company, or you pay a percentage, somewhere between 10 or 12%. Bonding companies will tell you what fee they charge. You would not get that money back. So whatever you pay to the bonding company, that's their money that you're paying them for that service.
Oh, so
Are you okay, sir?
I have disabilities and I have real disabilities and my social security income card came up missing when I got charged with the same trespassing and I'm missing. You know what I'm saying? So
It came up missing when?
when I was released from Victor Hill, or Claim County detention center. I was released from here. I didn't get my social security income card back.
Okay.
I got my ID back, and I didn't get my jewelry or my clothes. I just got my ID back. And I have disabilities. I have anger issues. I take Prozac and therefore antidepressants.
Okay. So it looks like you were arrested by the Clayton County Police Department. I'm sorry.
Not sure why.
So the allegation is that you told your roommate, Charles Pruitt, that you would beat him black and blue and that you would punch him in the face. And that's the allegation that's being levied against you right now.
Hey, can I talk to the judge? Yes, sir. Without you yelling in my ear?
There you go.
Me and Charles Pruitt, that's my mentor. He's a boxer. He's an ex-cop. We didn't have top 30 to each other. He had boxing gloves. It was an animosity to talk about my mom, something about my mom.
Okay.
It's not an issue. That's my mentor, and that's my landlord. But it's no problem. I'll pay the percentage through the bail bond about this.
Okay. Do you want me to see if you qualify for the appointment of a lawyer?
I want you to see if I qualify for my social security card, my social security income card to be replaced by Victor Hill.
So that is way outside of my jurisdiction. Okay. So it sounds like you're saying that you were arrested prior and that when you got released, you didn't get your social security card.
They brought me back for the same charge over again. Without my card, without my social, yeah. And I was like,
okay.
Business, I'm self-employed, I'm an engineer, so that's a lot of money.
So, Mr. Boyd, do you have people, like you said, there's an argument over your mother. Do you have people that can assist you?
Yeah.
Okay. So 2 things that you need to do, Mr. Boyd. One is when you post your bond, you make a request to see if you can get your card back. Because I don't know, I don't have the information of the other arrest, but hold on. So your information could be placed in property or it could be placed in evidence. If it's placed in property, that's the stuff that you get back when you're bonding out. If it's placed in evidence, you don't get that back until your case is over. Your lawyer can make a request if it's placed in evidence for a judge to sign an order for you to get that stuff back. Hold on. So the first thing, and you probably should have someone to assist you in this, but the first thing is to actually find out what happened. And then once you find out what happened, you know who you have to make the appropriate request of. Okay?
Yes, sir. I was going to say, the card is replaceable. I can contact my outpatient program, River Edge, and they can get me a replacement car. But I'm not sure why it wasn't returned back to me with the rest of my belongings and my jewelry and my clothes. But it's all, I can replace the car.
Okay, so the judge is not here to hear that. He's here to set your bond.
Okay.
So with that being said, let him say what he's got to do. And then after that, me and you will talk and I'll handle it, okay? I'm sorry, Judge.
No problem. Because that was going to be the second point that I was going to make, is that he could go ahead and just request a car. Because I don't know. I've never seen the car. I don't know where it is. Okay. So do you want me to see if you qualify for the appointment of a lawyer?
I'd rather pay the percentage with the bells behind me.
That's not to do with it. Lawyer's totally different.
So it's yes or no. It's your choice.
My choice is I want to pay the percentage of the bells behind me.
Okay, so I'm going to write on the form that you're going to represent yourself or hire your own lawyer. Do you have any other questions for me, Mr. Boyd?
I have disabilities. I have a mother.
I understand you have disabilities, and I can't do anything about your disabilities, right? I'm not at River's Edge. I'm not your doctors. I'm not your mother. I'm not the person to fix that issue, okay? So I've asked you a question directly, and you said you want to pay bond. So it's going to be pro se or hire your own lawyer. Is there anything else, Mr. Boyd?
Can I say something?
No, you're done.
I'm done.
I'm going to let Mr. Boyd ask his question, because all he's doing is prolonging his time in jail. So just ask me whatever question you want to ask.
Is it okay if my mother pays the percentage of my bond like she did the first time?
Yes.
And then I'll pay her back when I replace the car.
And you take that up with your mother. I would say do whatever you did last time to bond out. Do the exact same thing. Okay. Anything else, Mr. Boyd?
Bless that.
Okay, you're free to go back. Okay, Mr. Brown. Mr. Brown, sir, you charged with driving on a suspended license, giving a false name, address, and date of birth, and knowingly operating a vehicle without insurance. You're going to have a total, you're going to have a total bond set at $3,500. Can you post that bond, sir? You're going to have a preliminary hearing date set for June 29th at 8:30 in the morning. That date will get waived upon your bonding out, and you'll get a new court date in the mail. Would you like for me to see if you qualify for the appointment of a lawyer? You do qualify. I'm going to appoint a lawyer to represent you, Mr. Brown. Do you have any questions for me? Okay, you're free to go back.
Mr. Chavez? No.
Mr. Chavez, sir, you're charged with one count of driving under the influence of alcohol and one count of having an open container in your vehicle. You're going to have a total bond set at $5,500. Do you believe you can post that bond, sir? You're going to have a preliminary hearing date set for June 29th at 8:30 in the morning. That date will get waived upon your bonding out, and you'll get a new court date in the mail. Would you like for me to see if you qualify for the appointment of a lawyer? You do qualify, Mr. Chavez. I'm going to appoint a lawyer to represent you. Do you have any questions for me, sir? Okay, you're free to go back.
Wait. Say your name.
Oh, try me down.
Mr. Dawkins, sir, you've been charged with one count of family violence as a second offense and one count of criminal trespass. So the charge of family violence battery as a second offense is a felony, and the bond goes up to $10,000. So it's going to be $10,000 for that and $3,000 for the criminal trespass, for a total bond of $13,000. Do you believe you can post that bond, sir?
Yes, sir.
You're going to have a stay away provision on your bond to stay away from Ronald Dawkins. Do you understand that? You're going to have a preliminary hearing date set for June 30th at 8:30 in the morning. That date will get waived upon your bonding out. Do you want me to see if you qualify for the appointment of a lawyer?
Yes, sir.
Okay, you do qualify. Sir, I'm going to appoint a lawyer to represent you. Do you have any questions for me?
No, sir.
Okay, you're free to go back.
Your Honor, Mr. Klein was a transfer.
Okay. That was the person, the other fugitive.
Yes, sir.
Are you saying, when you say transfer, are you saying he's no longer in your custody?
No, no, sir, he's not.
Okay.
I have Mr. Denike.
Thank you for the information. Mr. Denike, sir, you're charged with 1 count of possession of a handgun by a person under the age of 18. This is being written up as a misdemeanor. I'm setting a $5,000 bond. Do you believe you can post that bond?
Yes, sir.
You're going to have a preliminary hearing date set for June 29th at 8:30 in the morning. That date will get waived upon your bonding out, and you'll get a new court date in the mail. Would you like for me to see if you qualify for the appointment of a lawyer? I'm sorry?
Yes, sir.
Okay. You do qualify, sir. I'm going to appoint a lawyer to represent you. You're a young guy. Don't go down this path. It's not going to be a good path for you. Okay?
Yes,
You're
sir.
free to go back.
Mr. Escalada.
Mr. Escalar, you've been charged with 1 count of criminal damage to property in the 2nd degree and 1 count of disorderly conduct. There's going to be a stay away provision on this bond, but first, your total bond is going to be set at $4,500. Do you understand that? There's going to be a stay away provision on the bond to stay away from 3950 Jonesboro Road, Forest Park, Georgia, also known as Rumors Gentlemen's Club. Do you understand that? Your preliminary hearing date is going to be set for June 29th at 8:30 in the morning. That date will get waived upon your bonding out, and you'll get a new court date in the mail. Do you want me to see if you qualify for the appointment of a lawyer? Okay, you do qualify. I'm going to appoint a lawyer to represent you. Do you have any questions for me? Okay, you're free to go back.
Mr. Fortson.
Okay, Mr. Fortson, you've been charged with 1 count of theft by taking and 1 count of family violence battery. You're going to have a total bond set at $7,000. Do you believe you can post that bond?
Yes, sir.
There's going to be a stay away provision on the bond to stay away from a Shanique Harris. Do you understand that? Your preliminary hearing date is going to be set for June 29th at 8:30 in the morning. That date will get waived upon your bonding out, and you'll get a new court date in the mail. Do you want me to see if you qualify for the appointment of a lawyer? I'm sorry.
Yes, sir.
Okay, you do qualify. Mr. Fortson, I'm going to appoint a lawyer to represent you. Do you have any questions for me, sir? Okay, you're free to go back.
Mr. Godby.
Mr. Godby, sir, you're charged with 1 count of terroristic threats or terroristic threats, actually. I'm sorry? Yeah, I had originally set your bond at $5,000. I'm going to reduce it down to $3,000. Do you believe you can post that bond? I did not put a stay away provision on the bond because it involves this leasing office. But do you believe you can handle yourself accordingly, sir, without me putting a stay away provision on your bond?
Get my property because I'm not going to stay here anymore.
Okay. So you understand now the way to get it is not to threaten people, correct? Okay. Do you want me to see if you qualify for the appointment of a lawyer? All right, you do qualify, sir. I'm going to appoint a lawyer to represent you. Your preliminary hearing date is set for June 30th. They have this written up as a felony offense. That date will get waived upon your bonding out, and you'll get a new court date in the mail. Do you have any questions for me, sir?
I'm going to get back and forth because my contract is supposed to be until the 30th. And I'm not going to have address for the next couple of months. They won't take my money.
I'm sorry. Can you fully explain that? I didn't understand.
I won't be able to, I'm not going to have a place to stay there right now. I'm trying to get out here and claim my property. A lot of valuable stuff in the park. You're not.
Where is your property?
It's in South Lake Cove Court, Jonesboro.
Okay, so as you're going through the process of bonding out, you're going to have to make arrangements with the sheriff's department for them to meet you at that location to obtain your property, okay? And then you pack all your stuff up and that'll solve that issue. Any other questions?
Okay, well, what about the lease that goes on until November 30th, which I didn't get 60 days. I just got it on the 10th. Yeah.
And I'm having a hard time to hear you. So I heard the word lease and I heard the word the 30th. So could you just kind of speak up a little bit and repeat that?
They sent me the letter on the 10th. I didn't get it until the 11th. On the 12th, they told me I had to get out. I just had to get out of jail the other week from them. Same thing. When there's something, I got to check it and everything. They wouldn't take it.
Okay, so you were arrested before?
It was thrown out.
Okay, and then you got a notice from the apartment complex saying that you had to leave by a certain date. And what was that date?
This month. The first, the 29th, I gave them an $854 check. They told me they wouldn't take it. They didn't give me no time to get out of that. Then they called back.
Right. So in the law, as it relates to dispossessory, if a landlord takes any kind of payment, it could be the complete amount or it can be something less than. Hold on. I'm trying to help you, sir. It starts the whole process over. So when they said they weren't going to take the money, that is a clue to you that is their intent to have you leave that residence. So you're going to be able to stay there until the process of your going to court. Okay. And I don't know when that's going to be. All right. So you bond out today. I didn't put a stay away provision on your bond. You bond out today. It sounds like you still have a lawful right to be there. Did they give you, either through the police officer or anyone in the leasing office, did they give you what's called a trespass warning, meaning do not come back?
Yes, sir, they did.
Okay, so you cannot go back. And sir, as you can understand, as a judge, I can only tell you the law. I'm not your lawyer. You can go hire a lawyer. I've appointed a lawyer. You can get legal advice from a lawyer. But if you've been given a criminal trespass warning, you cannot go back unless it's with the sheriff's department to obtain your items. If you go back, you're going to get arrested and charged with criminal trespass, and you will be back in jail again. Okay. Any other questions, sir?
Yeah, I'm going to call somebody and call the police to go over there.
I've set a bond at $3,000. There's not going to be a cost for the police to go back over, the sheriff's department to go back over, but you're going to have to speak to them about that. Okay. All right. You're free to go back, sir.
Mr. Hart.
Okay, give me 1 second, Mr. Hart. So you're charged with 1 count of possession of marijuana less than an ounce and 1 count of obstructing an officer. I'm going to dismiss both of these charges. And so when the paperwork gets over to the sheriff's department, you'll be free to go.
Thank you, sir.
You're welcome. You're free to go back.
Mr. Eilis.
Mr. Eilis, give me 1 second, sir. I'm sorry. So you're charged with 1 count of robbery and 1 count of obstructing an officer. It appears that as though you're on probation. So I cannot set a bond on the robbery charge. I've set a $2,000 bond on the obstructing an officer charge. Would you like for me to see if you qualify for the appointment of a lawyer?
Yes, sir. It's parole. It ain't probation. It's parole. It's the same
Okay.
Same thing. Yes.
Yep. It's the same thing.
Yeah, how much the bond for the obstruction?
I'm sorry.
How much was the bond? How much was the bond for obstruction?
It was 2,000.
Oh, thank you, sir. But no, not on the robbery, right?
Yeah, the robbery, like I can't, by law, I can't set a bond at this proceeding. I'm appointing you a lawyer. Your lawyer can contact the DA's office and they can work out a consent bond and you can be released tomorrow. But it's just by law, I cannot set it at this hearing. I'm going to set a preliminary hearing date for June 30th, and I'm going to set a bond hearing date for July 2nd. But it's my understanding that the district attorney's office is working these cases a lot faster. So you're probably going to have something heard or done on your case before those dates come up. I've actually had people who they either were denied bond or whatever, and they come back to me on a new charge before their court date that was set for the old charge. So talk to your lawyer. Your lawyer be the person that can help you out, okay? All right, you're welcome.
Mr. Langdon.
Mr. Langdon, sir, you're charged with 1 count of simple battery and 1 count of aggravated assault. I've set a total bond at $10,000. Do you believe you can post that bond?
Yes.
There's going to be a stay away provision on this bond to stay away from Derek Langdon. Do you understand that?
Yes.
You're going to have a preliminary hearing date set for June 30th at 8:30 in the morning, but that date will get waived upon your bonding out, and you'll get a new court date in the mail. Do you want me to see if you qualify for the appointment of a lawyer?
No, I'm gonna get my own lawyer.
Okay. Do you have any questions for me, Mr. Langdon?
No.
Okay, you're free to go back, sir.
Mr. Lyons.
Okay, Mr. Lyons, sir, you're charged with 1 count of possession of marijuana over an ounce and 1 count of possession of a weapon during the commission of a crime. And yes, you were arrested with Mr. Washington. So I'm setting both you and Mr. Washington a $10,000 bond on the possession of marijuana over an ounce charge and a $5,000 bond on the possession of a weapon during the commission of a crime. Do you believe you can post that total bond of $15,000, sir?
Sure.
You're going to have a preliminary hearing date set for June 30th because both of these are listed as felony offenses. That date will get waived upon your bonding out and you'll get a new court date in the mail. Do you want me to see if you qualify for the appointment of a lawyer?
Yes.
Okay, I'm going to find that you qualify. You're on the upper end of it, but I am going to appoint this lawyer. Do you have any questions for me, sir?
No, sir.
Okay, you're free to go back.
Mr. Moore.
Is Mr. Lowe not there?
No, I'm sorry, Your Honor. He was transferred as well.
Okay. And I'm gonna ask about that at the end, but Mr. Moore, sir, you're charged with 1 count of obstructing an officer and 1 count of criminal damage to property in the second degree and 1 count of battery. You're gonna have a total bond set at $10,000. Do you believe you can post that bond? You're gonna have a preliminary hearing date that's gonna be set for June 30th because the criminal damage to property in the second degree is being listed as a felony. That date will get waived upon your bonding out and you'll get a new court date in the mail. Do you want me to see if you qualify for the appointment of a lawyer? Okay, I will find that you qualify, sir. I'm going to appoint a lawyer to represent you. Do you have any questions for me? Okay, you're free to go back.
Mr. Rivera.
Sir, you've been charged with 1 count of terroristic threats or acts. I'm setting the bond at $3,000. Do you believe you can post that bond? Hold on. you're going to have a stay away provision on this bond to stay away from a Samara Bryant. Do you understand that?
Yes, sir, man. That's one question about that.
Yes, sir.
The same person that you mentioned literally tried to blow my head off, and the only thing I did is she was pointing a gun at me. I pretty much lost temporary intelligence and started blurting insanities.
Okay, hey, stop. You're on YouTube.
So, you don't want to talk about the facts of your case, all right?
What I'm saying is a gun was pointing at me. That's all.
No, I understand. So from what you just said, there's no question from the prosecutor, if they pull up this video, that you said something to her, because you've admitted what you said. You admitted that you said something. And what's written here is something that is listed as a threat. So even though it could be a defense to you, like let's say Miss Bryant is like, yeah, you know what, buddy, I did have the gun out. I'm just gonna let it go. The fact that you just said what you said, you could still be convicted of this, even though she's trying to let it go because of the words that you said that came out of your mouth. They're called admissions. So don't talk about the facts of your case. Talk about it with your lawyer. Let your lawyer represent you, sir.
All I was saying was a gun. That's it.
Okay. So do you want me to see if you qualify for the appointment of a lawyer? All right, I'm going to appoint a lawyer to represent you, but I think you've unknowingly made your lawyer's job more difficult for you, because all you're facing right now is a mere allegation. That's why I say we're not trying to try your case. So you could have done everything and be acquitted. You could have not done it and be found guilty, but that's for the further stages to go, okay? I've set you a bond. You don't have any value in trying to convince me of anything.
I was just saying, like, I was asking about, you told me to stay away from the girl, but she's the one who shot at me, sir. That's what I was saying.
So do you believe that that's a good idea or a bad idea for you to stay away from a person that pulled a gun on you? Do you think it's a good idea or a bad idea?
Sir, she was 2 inches from my face, sir, so yes.
Do you believe it's a good idea or a bad idea for you to stay away from a person that pulled a gun on you? Yes or no?
Good idea, sir. Yes, sir.
Okay. So I'm helping you out.
Yes, sir. Thank you.
All right. You're free to go back.
Mr. Rogers.
Mr. Rogers, sir, you're charged with 1 count of false imprisonment, 1 count of battery, 1 count of criminal trespass. Both you and Ms. Tyler were arrested as it relates to this incident. You're going to have a total bond set at $10,000. The false imprisonment is a felony offense. Do you believe you can post that bond, sir? There's going to be a stay away provision on your bond to stay away from Ms. Tyler. Do you understand that? You're going to have a preliminary hearing date set for June 30th at 8:30 in the morning. The date will get waived upon your bonding out, and you'll get a new court date in the mail. Is it your intention to hire your own lawyer?
Yes, sir.
Oh, okay. Do you have any questions for me, Mr. Rogers? Okay, you're free to go back, sir.
Mr. Stalls.
Is Mr. Seals OTB?
No, sir, but on your calendar, it has Stalls first. So that's why we put Stalls first.
Okay. Mr. Stalls, sir, you're charged with 1 count of family violence battery. The bond has been set at $5,000. Do you believe you can post that bond, sir?
No, sir.
Would you like for me to see if you qualify for the appointment of a lawyer?
Yes, sir.
Okay, I'm going to find that you qualify, Mr. Stalls. I'm going to appoint a lawyer to represent you. You're going to have a preliminary hearing date that's going to be set for June 29th at 8:30 in the morning. There's also going to be a stay away provision on your bond to stay away from a Lauren McDonald. Do you understand that?
Yes, sir.
So I don't know your financial situation, but I would contact the bonding companies that are authorized to write bonds in this county, because that's literally their only job, and they will work with people and trying to get them out. Do you have any? Yes, sir.
Well, my only problem is it's not the money situation, it's the job situation. If I'm not out there working, you know what I mean? I'm from Florida. I'm not from Georgia. I've lived here for years. So, you know, it's just me. So I'm paying my bond. And I have to find somebody who has a job to do all that. I mean, I haven't been in trouble in Georgia since I've been out here. And I just got done doing a 10-year bid in Florida 3 years ago. And I turned my life around. I'm like looking for like a blessing, like an ROR or something. You know what I mean? I'm not going back to the address. You know what I mean? I'm not a flight risk.
Okay, what I'll do, Mr. Stalls, is I'll reduce it down to $3,000, and hopefully that'll help you out.
All right, I appreciate it. All right, thank you.
Anything else, sir? All right, you're free to go back.
Mr. Seals?
Mr. Seals, sir, you're charged with one count of theft by shoplifting. It's set by schedule at $2,000. The bond, do you believe you can post that bond, sir?
Yes, sir.
You have a preliminary hearing date that's going to be set for June 29th at 8:30 in the morning. Do you, that date will get waived upon your bonding out, and you'll get a new court date in the mail. Do you want me to see if you qualify for the appointment of a lawyer? I'm sorry, sir.
Yes, sir.
Okay. You do qualify. I'm going to appoint a lawyer to represent you. Do you have any questions for me? Okay, you're free to go back.
Your Mr. Smith, we have to do a continuance. He did not want to come out.
Okay. Oh my goodness. This guy has a $500 bond. Give me 1 second. Mr. Burley, Miss Bernie sent me the waiver for Mr. Bakashi. I'm gonna check and see if you were on that. Do you know if you were on that email?
I can go back and check. Hold on, young.
Okay, I can easily just forward it to you. Okay, she did send it to me. I'm gonna forward it to you so that you'll have a copy of it. And if Mr. Bakashi signs the waiver, you can just have him sign it, and I will then, and then you can send it to me.
Yes, Your Honor. I think I just got it.
Okay. All right, so we're gonna have to do a continuance for Mr. Smith. Oh my goodness. You know what? What I'm gonna do, Mr. Burley, is his bond is already set by schedule. So I'm just gonna send the paperwork back. And just if he's choosing not to come, he'll at least have a bond and his case can get moving. And I'll appoint a lawyer to represent him, and I'll make a notation that my presumption based upon his charges is that he's probably mentally ill. So I'm gonna do that just so we're not just clogging the system up. And if his family members want to bond him out, they can bond him out. If not, he'll have a lawyer and his case can get addressed. All right, who do we have next?
Mr. Watley?
Okay, Mr. Watley, sir, you're charged with one count of family violence battery and one count of cruelty to children in the 3rd degree. You're gonna have a total bond set at $8,000. Do you believe you can post that bond, sir? I'm sorry.
Yes, Your Honor.
Okay, you're gonna have a stay away provision on your bond to stay away from a Rochelle Bryson. Do you understand that?
Yes, Your Honor.
Your preliminary hearing date, excuse me, your preliminary hearing date is gonna be set for June 29th at 8:30 in the morning. That date will get waived upon your bonding out, and you'll get a new court date in the mail. Do you want me to see if you qualify for the appointment of a lawyer?
Oh, Your Honor, I have one.
You do? Do you have any questions for me, Mr. Watley? Okay, you sir, you're free to go back.
Mr. Wallace?
Okay. Now, this is going to be a problem. I did not get the warrant information for you, Mr. Wallace, but this is a charge where bond is automatically set. So it's just going to be a situation of my having to get back with some of the people that work on the other side and getting that warrant information so it can get attached. But I do have a bond order for you, and your bond has been set automatically at $3,000. It's going to be a little bit higher because I have to add fees to it. But do you believe you can post that bond? Do you want me to see if you qualify for the appointment of a lawyer? I'm sorry.
Yes, Your Honor.
Okay, you do qualify, sir. I'm going to appoint a lawyer to represent you. And Miss Bernie, if you are listening, I don't have an LE number for Mr. Wallace, but his magistrate court case is 2021 WA 10236. And I'll send something in the chat to look for that. Do you have any questions for me, Mr. Wallace?
No, sir.
This is it's gonna be a misdemeanor charge, so you're gonna have a bond, I'm sorry, preliminary hearing date that's gonna be set for June 29th, but that date will get waived upon your bonding out and you'll get a new court date in the mail. So you're free to go back, sir.
Your Honor, I have his LE number if you need it.
Yes, would you give it to me?
218-9577.
Okay, 218-9577.
Yes, sir.
All right. I'm just sending a message to Miss Bernie now. All right. Now, do you have Mr. Warner next?
Yes, sir.
Okay. Mr. Warner, step on up, sir. You're charged with one count of harassing phone calls and stalking. I've set the bond at $5,000 apiece for $10,000 bond. Do you believe you can post that bond, sir?
So,
You're going to have a stay away provision on this bond to stay away from Sharonda Kaysen. Do you understand that? So if you violate these conditions, you can get an aggravated stalking charge and you will be held without bond. Do you understand that?
yes, sir.
All right, you're gonna have a preliminary hearing date that's gonna be set for June 29th at 8:30 in the morning. That date will get waived upon your bonding out and you'll get a new court date in the mail. Do you want me to see if you qualify for the appointment of a lawyer?
Sir, I have one question. You said,
Hold on, answer my question and I'll hear from you. Do you want me to see if you qualify for the, okay. You do qualify, I'm going to appoint a lawyer to represent you. Now, what's your question?
I'm gonna ask, is there any way the bond can be set just a little lower? Or, the person that's gonna help me is like disability, mother, but she'll post a bond for her.
Well, for situations like this, I'd set the bond a little bit higher because the allegation is that you called a Texas woman more than 200 times when she told you not to text her or call her. And so that's something that I need you to understand. These are serious charges and they could very quickly get you over into a situation where you're being held without bond. Okay. So I just need for you to understand that. All right.
Thank you for the bond. Thank you.
Okay. All right, sir, you're free to go back.
You have a nice day.
You too.
Mr. Washington?
Mr. Washington, sir, you're being charged with 1 count of improper signal, 1 count of violation of Georgia Controlled Substance Act, and 1 count of possession of weapon during the commission of a crime. I've set your bond at the same amount as I set the person that was in the vehicle with you. It's going to be $10,000 for the drug charge, $5,000 for the possession of weapon during the commission of a crime, and $500 for the allegation of the improper turn. So you're gonna have total bond set at $15,500. Can you post that bond? You're gonna have a preliminary hearing date set for June 30th at 8:30 in the morning. That date will get waived upon your bonding out, and you'll get a new court date in the mail. Do you want me to see if you qualify for the appointment of a lawyer? Okay, you do qualify, sir. I'm going to appoint a lawyer to represent you. Do you have any questions for me?
Yes, sir. I was notified that when I was being intake, it was erratic lane change. Is that the same charge as failure to signal?
Yeah, it's the way it's written. It says improper / erratic lane change. And the statute is 40-6-123A. And so the basic allegation is that you're the driver and you made some kind of sudden or sharp turn into this driveway, and that's what piqued their interest. So all of these charges are just mere allegations. The state is going to have to prove each element beyond a reasonable doubt. That's why we appoint lawyers as quickly as possible so you can speak to your lawyer and you can start defending yourself. Okay, any other questions? Okay, you're free to go back, sir.
And lastly, Mr. Bakshi.
Okay, sir, you've been charged with 1 count of being a fugitive from justice. And the allegation is basically that there is a warrant for your arrest out of Shelby County. And I'm assuming that's Tennessee. So you're the first person that I've had that has a fugitive warrant and you have no criminal history. So whatever this is something that has not been inputted into the system yet. So I don't even know what the charge is. This hearing is something where all of the rights that we discussed before with everyone else, they apply to you. But you are in a separate situation. You're not being held by Clayton County for any allegation that you committed a crime here. You're being held according to an interstate compact, where if someone says that there's a warrant for your arrest, we are duty bound to hold you until they decide that they're going to come and get you. They have a time period that can be up to 60 days, but it's a 30-day initial time period. They can request additional time. You have a right to fight that process. And if you say, look, I don't want to sign the waiver, I want to fight it, you'll get placed on a calendar, and sometime within 30 days, you will have a hearing before a judge here in magistrate court. And at that hearing, we're basically trying to determine if you are the person named in the warrant and if the allegation that they're making against you is something that is a valid charge, a true charge. And if we make that determination, then we sign the documentation, and then that 60-day clock begins to run. If you believe that you are the person named in the warrant and you believe that these charges that are pending may be valid charges, you also have a right to waive that hearing. And you can say, I want to waive that hearing, and I'll sign the documentation, and then the clock will begin to run today. Now, the important thing to note is that if the clock runs out and they never come and get you, Sheriff's Department will contact them and say, hey, you didn't come get him, we're releasing him. Now, even though you're released, it doesn't mean your warrant goes away. So you can walk out the front door and 5 minutes later you have an interaction with law enforcement and you get arrested and everything starts all over again. So it's always in your best interest to kind of confront these charges up front and not to just try to see if you can get released. Have I made sense to you?
Yes, sir.
Have you had an opportunity to think about this as to whether you want to waive that hearing or whether you want to have that hearing?
I believe so.
Okay. What is your desire?
I think I should just waive it.
Okay. So I emailed over the documentations, a document over to Deputy Burley, and he'll have an opportunity to print it out and give it to you for you to sign. And then he'll send it over to me and I'll sign it and the clock will begin to run today. Now, during this time, you also can hire, and it's probably in your best interest to hire a lawyer up in Shelby County to start dealing with this as quickly as possible. Because a lot of times, especially now, depending on the charges, they may agree to a bond that you can agree to, and then they'll contact the sheriff's office here and say, hey, release him, and they'll release you. And you just have to show up to whatever court date that they've agreed to set. Okay. So there are other things that you can do to hasten this process. So do you have any questions for me?
No, sir.
Okay. So they'll present the documents to you, and then once you sign those documents, you'll be free to go back.
Thanks, sir.
You're welcome. All right, Deputy Burley, I have a question for you. You said that Mr. Klein and Mr. Lowe, you said they were transferred. So what does that mean in like basic language?
Another department came and got them.
Okay. All right.
If I'm not mistaken, Lowe's being transferred to another department.
Okay. Okay, so I'll write that down. Thank you, sir, for your patience and your assistance. I'm going to try to get these documents out as quickly as possible. It would help if you can get that for Mr. Bakshi to sign that waiver and get that done as quickly as possible. So that'll help me on my end.
Yes, sir.
All right, thank you, sir.